Hello, everyone, and thank you all so much for joining us on our weekly Friday webinar. Today, I am joined by our awesome managing attorney, Ruby Powers, and we are here to discuss what is Section 245I and how does it help your case. Just some quick background on our managing attorney. She has been licensed since 2008 and founded her firm back in November 2009, and she's also a board certified immigration and nationality attorney. Attorney Powers, you want to take it away?
Yes, thank you, Daya. So, immigration is complex, and we try to give you these weekly Friday webinars to give you sort of make more sense and give you a deeper dive into different areas. There's so much to talk about. And what we do here at Powers Law Group is when we talk to our clients, we review all possibilities. They might come in saying, I want to talk about A, and we're just like, okay, let's talk about that. But let's also explore B and C, because you never know, there might be something better or maybe something you didn't even explore before. So that's part of our job, is to make sure that we leave no stone unturned. So there's this one thing that might sound obscure. You're like, why are you telling me all these numbers and letters and stuff? Well, because that's sort of how immigration attorneys in the world works over here in the legal immigration space. But it's a provision in the Immigration and Nationality Act under, well, here's an old version, but basically the INA, and well read and well underlined. But it's under 245I. And so I'm going to talk about the eligibility, who's grandfathered under it, and so just what a qualifying petition or labor certification is, and just the general other things to consider when you're looking at this. So just to go into like a little bit of the minutia of it, it's in the INA, Immigration and Nationality Act, and enables certain individuals who were present in the United States who would not normally qualify to apply for a legal permanent residency adjustment status in the U.S. to obtain the green card, regardless of how they entered, working in the U.S. without authorization, or failing to continuously maintain lawful status entry. So normally, and I'll read the rest in a second, but normally if you enter legally and you want to change status to something else, if you worked illegally or you overstayed a visa, you can't adjust to something else. But this is one of the ways, unless you are an immediate relative to a U.S., your immediate relative, which is basically being the parent of a U.S. citizen, 21 and up, being a spouse of a citizen, or being a minor child of a U.S. citizen. So that's pretty specific. So most people who overstayed or entered illegally or worked illegally without status, without authorization, would not be able to move forward because of the visa that the way they're getting their visa and how they entered and things like that. So I hope that made sense. But so to qualify for this provision, you must be the beneficiary of a labor certification. So we're talking about through work. The work is trying to sponsor you. Form ETA 750, or an immigrant visa petition. So that's usually the I-130, which is family-based, or I-140, which is worker employment-based, and filed on or before April 30th, 2001. So that's that magic day that happened we're almost up to 21 years ago. So that's why like some of my staff is younger than that, and that date. So that's why a lot of times people are like, what is this thing? And so when we do obscure provisions that could still be beneficial to this day, this is one of them, and it's not that old. But it is first, yeah, it's all relative, right? So it had to be filed on or before April 30, 2001. And you have to complete, so if you were to use this, then you need to follow the rest of the provisions, which we're going to say. But one of the things that you have to do to use it is you have to pay an additional filing fee of $1,000. And you also have to fill out an extra form. and we'll talk about that. So let's go ahead and move to the next step. And I hope this is making sense, because really it can be a little confusing. Like, let's say, hypothetically, let's say your grandpa petitioned for your mom, and you were a teeny little kid. Maybe you weren't even born yet. And no, let's say you're a little kid, and you're let's say you're in the United States, and you were born in Mexico, and your mom, but they sort of forgot to put you on the petition because it was like crazy, and they were trying to file it on time. But your grandpa was a U.S. citizen, and they petitioned for your mom. Now, what would basically happen is that petition's like super old. Maybe you can't even use it anymore because you're grown up and everything, but you could use that for the sole purposes of acting sort of like, in a way, like a legal entry. If you want to, it'll allow you to, and now let's say you're married to a US citizen, but you entered without inspection, but you have that old grandpa petition that was for your mom, and then you were underneath that. So what that really means is that you could use one petition, that old one, for your to allow you to adjust status without a legal entry and maybe having overstayed. And you can use your spouse to US citizen petition to give you a visa available now. So sometimes the petitioner for the 245I petition is, sometimes you have two petitioners. You have one, for example, for 245I, and you have one to give you the visa. So I hope that makes sense, but maybe we just replay that a couple of times. But really, that's why we have consults, right? So to be eligible, you are the beneficiary of a qualified immigrant petition or a labor certification filed on or before April 30th, 2001. Now, it just had to be approvable when filed, one of those petitions. It doesn't mean that you are using that petition to this day, okay? Maybe that relationship doesn't exist, maybe that employment doesn't exist, so you just had to be the beneficiary of a qualified immigrant petition at that time. Now, the second thing is that you were physically present in the United States on December 21st, 2000. So this is only if you're the principal beneficiary and the petition was filed between January 15th, 1998 and April 3rd, 2001. Okay, so what is all that saying? Basically, if we're using a petition that was filed between January 15, 1998 and April 30, 2001, so we'll say more of a recent one, right? Then the principal beneficiary has to show that they were here on December 21st, 2000. Sometimes you can't show that because we don't have a lot of proof, and hey, that's like 1 years ago. Well, what you would do is maybe you would show some proof from November 2000, and maybe some from January 2001, and you just do your darndest. And especially if like maybe the beneficiary is like a stay-at-home parent and they don't have a lot of documentation, or they weren't on a lot of records. We've been successful in the past, but basically you have to work really hard to give them as much and show the absence of documents if you can't find things. So that's why these can be very hard, because we're talking about maybe you have to wait a long time for the visa to become current or to be eligible under another visa, but then you got to go back a long time ago and show this proof. So number 3 is you're currently the beneficiary of a qualifying immigrant petition. So you get what I'm saying? Like maybe use some old petition to use the 245I part, but then you need and that allows you to overcome having entered illegally, worked without authorization, or what was the other one? Failing to maintain your status. But then you need to have your visa available. And it could be another way. It doesn't have to be the same petition, right? Okay. Now, and you need to file the I-45. You need to pay the $1,000 supplement. Okay, 45 plus the 45 supplement A. Supplement A is only for the 245I people, okay? And you pay the $1,000 fee that's in it. So the I-45 right now, as of recording in January 2022, can you believe that? The filing fee for I-45 is $1,225. The filing fee for the I-45A for the 245I purposes is $1,000. So you need to physically be present at the time you file all this stuff. You need to have the visa available to you now, and you're admissible to the US or eligible for the waiver, and you warrant favorable exercise of discretion. Means you're not a bad person, and the positive outweighs the negative. Now, depending on the circumstances, a spouse or child of a grandfathered individual may also be grandfathered or be eligible for the 245I. This is where it gets a little tricky. Sometimes people are eligible to use this and they don't even know. And so a lot of times that's where we're like the diamonds in the rough for being detective, because it's like, well, that's why we ask in our intake, did anybody petition for your parents? Did anybody petition for you? And we ask questions like, who in your family is a US citizen or legal permanent resident? Because we're trying to figure out maybe, and maybe you don't know the answer, did somebody petition for somebody that's somewhere in a qualifying relationship that we can go dig up and use. And this has happened quite a handful of times or more. And what I'm finding is now that children are turning closer to 21, people do have these petitions they were just waiting to use when their child turned 21 so that they could pair them up. So what does grandfathered mean? What does that mean? So a beneficiary of a family-based visa petition or labor certification filed on or before January 14, 1998, you don't need to have any physical presence. So again, if it was filed on or before January 14th, then that December 21st date, we don't care about that. And beneficiary of a family-based petition filed between January 15, 1998, April 30, 2001, you have to be physically present in the US. So we've discussed that, and these dates might seem like gobbledygook and foreign to you, but don't worry, I have them memorized. And so these are very important to note. So the qualifying petition, the labor certification or visa filed to preserve the adjustment must be both properly filed, so it has to be signed and submitted, and approvable, means meritorious, based on the facts, and non-frivolous when filed. Literally, I have read this multiple times when I've been double checking things where we, and this has really saved us, approvable when filed. So like on the face of it, it could have been approved. Maybe it didn't get approved, but it was possibly able to be approved. And this has really helped save a lot of people, even though this might sound a little like, why did they make this up? But over many years, there was litigation and there was a lot of explanation of what all of these terms and exceptions would be. So to meet this test, the filing must have been timely filed and meet all the applicable substantive requirements. And that's why it'd be approvable when filed. Deficiencies such as lack of fee, original signature disqualify the submission. So that's pretty harsh, because now we can just use copies of signatures, but they were wanted original signatures back then. If it's withdrawn, denied, or revoked, if you withdraw the petition, or if the US or INS at the time denied or revoked it, you may still be grandfathered, depending on whether the visa was approvable when filed. To remain eligible, the changed circumstances must relate to factors beyond your control rather than the merits of the petition at the time. So just because an I-130 or a labor cert was denied, but if it was filed by April 30, 2001, you could still be good. Now, I remember that labor certifications were not done the same way back then. And so I think they were done with the individual state's labor department. It's always a little different. So you have to FOIA in a different location, but I've done cases like that. And anyway, those if you think you might have a case, it's worth doing some digging where we do Freedom of Information Act requests before you give up on that concept, because this can make huge difference and be whether or not you might have to go abroad to do and use waivers, or maybe you're not even eligible for anything at all. So if the petitioner dies or the employer otherwise is unable to maintain the petition, you should remain grandfathered if the as long as the petition or the labor cert application was approvable when filed. You can remain grandfathered if the petitioner dies, the family member who filed the petition divorces, the employer who filed the labor certificate goes out of business, the petitioner or the employer chooses to withdraw the petition, or the petitioner or employer is otherwise not able to maintain the petition or labor certification. So you still can use it. So don't give up hope. We might be going a little too much in the nitty gritty here, but basically it's like what we said, the I-140 and the I-145A. And then generally what you normally put in lots of these things are passport style photos, a copy of your ID, government ID, birth certificate, passport page of your visa, and proof of your stamps if you have those. Medical exam is good to have. Remember, now you need to have your COVID vaccine. And then the affidavit of support if applicable, and then showing the visas available plus the filing fees, which right now the I-45 is $1,225 and the supplement A is $1,000, and then proof that you're your grandfather. So this will allow you to adjust even if you entered without inspection, or you were out of status, or you violated terms of your non-immigrant status. So this is like really awesome because, like, for example, if you were grandfathered on a petition and then your sister petitioned for you and you're from Mexico and that takes like 20 years. Well, now the visa is available. You normally wouldn't be able to overstay your visa or overstay your status in the country or work illegally. But if you have this petition from a grandfathering, somebody petitioned for your mom or your dad or something, and then you have that visa petition available, then you could go ahead and adjust. So it might be complicated because it sounds complicated, because it is. You need to make sure everything aligns. And that's what we do when we look at your case and let you know. But ultimately, you could still be eligible for this right now, and maybe it could be something you could use in the future. So people mistakenly believe that this constitutes amnesty. Heck no, nope. There's only just some things that it helps you overcome, like in entry without inspection, working without authorization, and overstaying your visa. Those are the only things that it can help you overcome. It doesn't protect you from deportation. Nope. Some people get deported even when they have this, unfortunately, and that's not ideal, but maybe they didn't have a visa available for them at the time, or nobody knew what was about it. So if you are here without status in the US and you accrue unlawful presence until you apply, if you accrue 180 days of unlawful presence and then you depart, and then you trigger a bar, and then if you are here again, so in some instances, this potential permanent bar is not forgiven with 245I. Now, we definitely would have to look at the circumstances of the petition. Other grounds of inadmissibility may apply, based on crime or misrepresentation or fraud. So those are things we have to screen for. And an employer who files a labor cert or an I-140 with an unauthorized individual as beneficiary will be subject to sanctions if they're discovered to be knowingly employing that individual before adjustment. So, and once the individual files the 45, they can become eligible for work authorization once they receive the employment authorization documentation. So you have to wait to have. I guess hopefully my key takeaway is that this may seem obscure and relatively old, but it's still alive and well and being used on a regular basis. You think you might be eligible, or you might have a family member that petitioned for you, or a parent that you might be eligible for being grandfathered under. Make sure to collect that proof, have a consultation with somebody who's experienced with 245I, and have that documentation ready. Maybe you're waiting for, maybe you're going to marry a US citizen, or maybe your child 21 and up is going to be able to petition for you, and you can't file yet, but you can have done the Freedom of Information Act request. You can collect these documents. You can be ready and prepared so that you can move forward at the earliest available, because I'll tell you, the more time passes, it's harder to collect all this evidence. So I hope that was a good primer about 245I. And there's a lot of frequently asked questions.